Hi everyone, this is Gráinne Thornbury here, working with Seamus Kavanagh in the Irish International Freight Association. You're all very welcome here today for our first webinar of the IIFA FIATA Diploma course, Module 1 Freight Forwarding. As you are aware, there are 10 modules in total, each dealing with a different topic: air freight, sea freight, road freight, customs and dangerous goods, to name but a few. The freight forwarding module gives an overview of all of the topics covered, and for this reason contains a lot of information. For this particular webinar, I'd like to concentrate on some key aspects that are relevant, irrespective of any mode of transport and type of shipment being carried. Topics we are covering here today are legal relationships, when freight forwarder acts as agent and/or principal; standard trading conditions, conditions when freight forwarder acts as carrier, principal; contracts in international trade, elements necessary to make a contract; INCOTERMS 2010, methods of payment for seller-buyer; irrevocable documentary letter of credit. What is the legal relationship when the freight forwarder acts as an agent and/or principal? The freight forwarder acts as an agent when he arranges, procures the carriage. This means he subcontracts the transportation of the goods to the carrier owner of the services provided. In the event of any claims received, they are passed on to the carriers. The freight forwarder acts as principal carrier when he collects and delivers goods using his own means of transportation, his own equipment. He also acts as principal carrier when he provides and operates his own groupage container service. When acting as carrier, the freight forwarder has full responsibility for any claims received. According to FIATA Legal Handbook on Forwarding, a forwarder acting as agent need exercise only reasonable care in arranging transport for his client's goods. As principal, he undertakes to deliver the goods at destination and is responsible if the goods are lost or damaged, even if he has exercised reasonable care. Who are the carriers and the principals? The service providers and owners of the means of transport, they are the carriers' principals. These would be shipping lines, airlines, road haulage companies. The freight forwarder acts as agent when he makes a booking on behalf of his client. The contract is between the service provider and the shipper. In other words, the contract is between the shipper and the carrier. The freight forwarder is the link between the shipper and the carrier. When acting as an agent, the freight forwarder has less liabilities than when he acts as principal. The freight forwarder acts as carrier principal when he presents a groupage container to the shipping line or a consolidation to the airline. This means the freight forwarder has loaded his own groupage container, we'll say consisting of about 15 individual LCL shipments that are packed together and presented to the shipping line as one container, consisting of the total number of pieces loaded. The line will issue a master bill of lading showing the freight forwarder as the shipper and will be consigned to his agent at destination. In this case, in the event of loss or damage to any of the shipments, he has full responsibility. Standard trading conditions. Freight forwarders in Ireland who are members of the IIFA operate their business under the IIFA Standard Trading Conditions and Warehousing Conditions 2018 edition. This is the newly revised edition, came into effect in January 2018. The standard trading conditions protect the freight forwarder and limit his liability in the event of a claim. Limit of liability: 2 SDRs per kilo of the gross weight of the goods lost or damaged. SDRs are special drawing rights. They are a unit of account of the International Monetary Fund and they are made up of a basket of key currencies. The freight forwarder can apply a general lien. This means he can hold any consignment until all monies outstanding are paid, and not just money outstanding on that particular shipment. Time limit for claim is within 14 days of the event alleged to give rise to a claim. So if a delivery has been made and the client notices damages to the goods, they have to make a claim in writing within 14 days. Time limit for legal action. This is within 9 months of the event alleged to give rise to the claim. If the client does not bring legal action against the freight forwarder within the 9 months, the freight forwarder is discharged of all liabilities. Please refer to your manual, Learning Unit 1.12 for an explanation of the standard trading conditions, and you will find a full copy in the appendices. This will make very good reading. I'm sure you'll agree. How can the forwarder ensure he will be protected by his STCs? This is a very important matter for the freight forwarder. When the freight forwarder enters into a contract with his client, the standard trading conditions have to be incorporated into the contract. This means that the client should be made aware that all business is transacted in accordance with the company's standard trading conditions, copy available upon request. A contract can be written or verbal. If the verbal contract was not made expressly subject to the client accepting the standard trading conditions, then it is too late to try and introduce them after the contract has been concluded. There are various ways the freight forwarder should advise the client of the standard trading conditions. At time of quotation, when the forwarder quotes for the business, the client should be made aware of the STCs. Send a copy of the standard trading conditions to the client and request confirmation in writing. The STCs are also printed on the reverse of the freight forwarder's documentation, for example on the house bills and freight invoices. Reference should be made to the standard trading conditions on all communication between the forwarder and his client. This would include emails and letterheads. How is the freight forwarder protected when he performs as carrier principal? The forwarder takes out insurance to cover all of the services he provides. As agent, he is protected under the IIFA standard trading conditions. If he provides services as carrier principal, he is protected under various rules and conventions. Air freight shipments. When the forwarder presents his own consolidation to the airline, he is protected under the Warsaw-Montreal Convention. This limits his liability to 19 SDRs per kilo of the gross weight of the goods lost or damaged. For sea freight shipments, when he presents his own groupage container to the line, he is protected under the Hague-Visby rules. The limits of liability are 666.67 SDRs per unit or package, or 2 SDRs per kilo of the gross weight of the goods lost or damaged, whichever is the highest. Road freight shipments. When he performs his own international road freight transport, he is protected under the CMR Convention. This is the convention on the contract for the international carriage of goods by road. The limit of liability is 8.33 SDRs per kilo of the gross weight of the goods lost or damaged. There will be more detailed information on limits of liability in the air freight, sea freight, road freight and insurance manuals later on in the course. There can be up to 4 contracts in an international transaction. 1. Contract of sale. This is between the seller and the buyer. This contract should include all the details of the transaction with regards to the goods and the method of payment. The rules concerning the contract of sale is governed by the United Nations Convention on the International Sale of Goods of 1980, also referred to as the Vienna Convention. Number 2. Contract of carriage. This is between the shipper and the freight forwarder and/or the carrier. Number 3. Contract of payment, between the seller and the buyer, and this very much depends on the relationship between the seller and the buyer. And number 4. Contract of insurance. This is between the insurance company underwriting the risk and the insured. The insured can be the seller or the buyer, depending on whose responsibility it is to take out the insurance, and this very much depends on the INCOTERMS used. The following elements are necessary to make a contract. Offer and acceptance. An offer has been made and has been accepted. Intention to create legal relationships. The intention to enter into a legally binding contract and accept the conditions of same. Parties to the contract must have the capacity to do so. The capacity to enter into a legal agreement and be competent and have a sound mind. Must be a consideration. This means there has to be a payment. No vitiating element. This means no mistakes, signing under duress or misrepresentation. What are INCOTERMS 2010? They are a set of rules and definitions of the more often used terms, also referred to as international commercial terms. They are used to clearly state the responsibilities of the buyer and seller, Who pays what costs and who carries the risk if loss or damage occurs to the shipment while en route to its destination? At what point is the risk transferred from the seller to the buyer? This transfer of risk is not necessarily at the same point when the costs and responsibilities of moving the shipment are transferred from the seller to the buyer. This depends on the various INCOTERMS used. The INCOTERMS are published by the International Chamber of Commerce. They relate to international commercial law and they are accepted by governments and legal authorities around the world. Please refer to Learning Unit 1.13 in your freight forwarding manual and also refer to the chart of responsibility that is located on Moodle. There are 11 INCOTERMS in total. On the left they are all freight collect terms and on the right they are all freight prepaid terms. There are 4 terms that are used only for sea freight and inland waterways. They are FAS, free alongside ship at port of loading, FOB, free on board at port of loading, CFR and CIF, cost and freight, cost, insurance and freight at the named port of destination. All of the other INCOTERMS can be used for any mode of transport. There are so many tasks, costs and risks in the movement of an international consignment, and it can be a minefield as to who is responsible for what. We'll just have a look here at some of the items that have to be taken into account when transporting an export shipment to a country outside of the EU. Professional packing if required, who'll arrange it and who's going to pay for it. Export licence if required. Local collection, export customs clearance, origin terminal handling, main freight carriage of the goods via air freight, sea freight or road freight. Insurance. Now there are only 2 INCOTERMS where this is specified, CIF and CIP, and even this requirement is only for minimum cover. For all other INCOTERMS, it should be agreed between the seller and the buyer in the sales contract who will take responsibility for the insurance. So now the goods arrive at the country of import. So we have terminal handling, import customs clearance, duty and VAT, local delivery to the final destination. At what point is the risk of loss or damage to the goods transferred from the seller to the buyer? When does delivery take place? This doesn't mean the physical delivery of the goods. It refers to the point when the risk is transferred from the seller to the buyer. There can be a lot of disputes between the seller and the buyer if they don't fully understand the implications of the various INCOTERMS. The buyer can find he has to pay a lot more costs in relation to the importation of his goods than he had originally budgeted for. You, as the freight forwarder, can find you have a very unhappy customer if you've given the wrong advice. Ex works is ex factory, ex shipper's premises. This is the minimum obligation of the seller. All the seller has to do is make the goods available for collection, supply a commercial invoice. It is not his responsibility to provide an export licence if required, or customs clear the goods for export. If the goods require a professionally made wooden crate for shipment, then it is up to the buyer to arrange and pay for it, unless it's written in the contract. The buyer is responsible for all costs and risks involved from the seller's premises to delivery to the desired destination. So the risk for loss or damage to the goods is transferred from the seller to the buyer upon collection of the goods. Also, the buyer should take out marine insurance cover on the goods, since he's the party who will suffer the losses in the event of loss or damage to the goods. So for ex-work shipments, they are freight collect, and this INCOTERM can be used for any mode of transport. FCA, free carrier arrival at the named place. The seller is responsible to deliver the goods to the carrier for export at the named place as instructed by the buyer. As this is shipping on a freight collect basis, the buyer is controlling the routing and shipping costs. The seller is responsible to provide all documentation required for export and export clearance of the goods. The risk for loss or damage to the goods is transferred from the seller to the buyer when the goods have been delivered to the carrier. From this point, the buyer is responsible for all costs until the goods have been delivered to the desired destination. Point to note here is that the buyer is also responsible for the origin terminal handling costs. The buyer should take out a marine insurance cover, since he is the party who will suffer the losses in the event of damage or loss of the goods. However, this should be agreed by both parties in advance, as this INCOTERM does not specify who should take out the insurance. FCA can be used for any mode of transport. FAS, free alongside ship at the named port of loading. The seller is responsible to place the goods on the quay beside the ship. FAS is used for certain commodities such as grain, timber, steel products that cannot be individualised. The seller is responsible for the origin terminal handling charges, and the buyer is responsible for actually loading the goods on the ship. The buyer is responsible to provide all export documentation and customs clear the goods for export. Risk of loss or damage to the goods is transferred from the seller to the buyer when the goods are delivered to the quay at the named port of loading. So the buyer is responsible for loading the goods on the ship, the sea freight charges and all other costs up to delivered the desired destination. The matter of insurance should be agreed in the sales contract prior to shipment between the seller and the buyer. This INCOTERM is only to be used for sea and inland waterway transport. FOB, free on board at the port of loading. Shipped on a freight collect basis. The seller has fulfilled his obligation when the goods are physically on board the vessel. The seller has to provide all export documentation and customs clear the goods for export. He is responsible for all the costs up to this point. The risk of loss or damage to the goods is transferred from the seller to the buyer when the goods are on board the vessel. The seller and the buyer should agree in the sales contract which party will take out the marine insurance cover on the goods. The buyer is responsible for all costs and risks after the goods have been loaded on board the vessel, up to delivery at the desired destination. This INCOTERM should only be used for sea and inland waterway transport. CFR, cost and freight, and CIF, cost, insurance and freight, up to arrival at the port of destination. These shipments are shipped on a freight prepaid basis. The only difference between these two INCOTERMs is that CIF specifies that the seller is responsible to provide the insurance cover on the goods. It should be noted that only minimum cover is required, and if the buyer wants extra cover, he needs to arrange this himself. For CFR shipments, the seller and the buyer should agree in the sales contract who will carry this responsibility. The seller is responsible for all costs and tasks up to arrival at the port of destination. The terminal handling charges at destination and all other charges up to delivered the desired destination are for the account of the buyer. An interesting point to note here is that although the seller is paying for the goods up to arrival at the port of destination, the risk is transferred from the seller to the buyer when the goods are placed on board the vessel in the port of loading. So in this instance, the responsibility for costs and the transfer of risk does not occur at the same time. These INCOTERMs should only be used for sea and inland waterway transport. CPT, carriage paid to, and CIP, carriage insurance paid to, named place of destination. Goods are shipped on a freight prepaid basis. The only difference between these two INCOTERMs is that CIP specifies that the seller is responsible to provide the insurance cover on the goods. It should be noted that only minimum cover is required, and if the buyer wants extra cover, he needs to arrange this himself. For CPT shipments, the seller and buyer should agree in the sales contract who will carry this responsibility. The seller is responsible for all costs and tasks up to the named destination, including destination terminal charges. The buyer is responsible for all costs from this point: import customs clearance, payment of duty and VAT, and final delivery to the required destination. An interesting point to note here is that although the seller is paying for the goods up to named place of destination, the risk is transferred from the seller to the buyer when the goods have been delivered into the custody of the first carrier. So in this instance, the responsibility for costs and the transfer of risk does not occur at the same time. These INCOTERMs can be used for any mode of transport. DAT, delivered at terminal at the named port or place of destination. The goods are shipped on a freight prepaid basis. The seller is responsible for all costs and risks in delivering the goods to the terminal, including the destination terminal charges. The risk is transferred from the seller to the buyer when the goods have been unloaded and placed at the disposal of the buyer. From this point on, the buyer is responsible to arrange the customs clearance, pay the duty and VAT, and the delivery to the required destination. This INCOTERM does not specify which party should take out insurance. It should be agreed between the seller and the buyer in the sales contract. This INCOTERM can be used for any mode of transport. DAP, delivered at place, shipped on a freight prepaid basis. The seller is responsible for all the costs and tasks involved in delivering the goods to the named place. This includes the destination terminal charges and the delivery. The buyer is responsible for unloading the goods, import customs clearance, and payment of duty and taxes. Risk is transferred from the seller to the buyer when the goods are delivered, ready for unloading. This INCOTERM does not specify which party should take out marine insurance on the goods. It should be agreed between the seller and the buyer in the sales contract. This INCOTERM can be used for all modes of transport. DDP, delivered duty paid at the named place of destination. The seller is responsible for all tasks, risks and charges, including import customs clearance, duty and taxes, involved in delivering the goods to the named place of destination. In order for the seller to have obtained the full detailed breakdown of all of the local charges payable at destination, his freight forwarder would have relayed concise details of the shipment, including the tariff number, to his agent at destination. All of the detailed charges would have been emailed back to the freight forwarder at origin, and the seller would have been quoted accordingly. This can be a time-consuming process for the freight forwarder when arranging the export of a DDP shipment. The risk is transferred from the seller to the buyer when the buyer has taken delivery of the goods. This INCOTERM does not specify which party should take out marine insurance. It should be agreed between the seller and the buyer in the sales contract. This INCOTERM can be used for all modes of transport. There are various methods the seller may use to secure payment for his goods. Open account. If a seller is dealing with a long-standing customer and they have an excellent business relationship and payment track record, then they may conduct their business under open account. The seller ships the goods and sends all documents directly to the buyer. The buyer can then get release of his cargo immediately upon arrival. The buyer makes payment to the seller in accordance with their agreed method of payment. This could be cheque, bank draft, or electronic transfer of funds. Cash and delivery. In this case, the seller asks the carrier to collect payment for the goods from the buyer when the goods are being delivered at destination. The forwarder should be extra careful because if he fails to get the payment for the goods at the time of delivery, then he may be liable to the seller for the cost of the goods. Cash against documents. This is when the bill of lading is made out to a bank. The bank will only release the bills of lading when the buyer has paid the charges due. The buyer needs to have an original bill in order to get release of the cargo. An original bill has to be surrendered to the carrier or named agent at destination, so in this case, no original bill, no cargo. Documentary letter of credit. One of the most secure payment methods in international trade, often used when the parties involved are not familiar with each other and the exporter wants to ensure that he will get payment for his goods. The bank issuing the LC guarantees that the exporter will receive payment once the terms of the documentary credit have been met. I've given this a smiley, as the shipping document required, a bill of lading, needs the expertise of the freight forwarder. The freight forwarder needs to have a thorough understanding of the precise procedures required to successfully complete the bill in line with the letter of credit stipulations. The irrevocable documentary letter of credit is a method of payment ensuring the seller gets paid for his goods. It is arranged by the buyer through his bank. This is one of the most secure payment methods in international trade. Irrevocable changes to the letter of credit cannot be made without the agreement of all parties. The seller should always ensure that the letter of credit is irrevocable, as protects him in the transaction. The International Chamber of Commerce has drawn up the rules to protect all parties to a documentary credit, and this is called the Uniform Customs and Practice UCP 600. We'll just have a quick look now at some of the terminology used in the letter of credit. The seller of the goods is also referred to as the beneficiary. Ask yourself, who is going to benefit by getting paid? The seller. The buyer of the goods is also referred to as the applicant. Ask yourself this question: who applies to the bank to open the letter of credit? The buyer. The seller's bank is the advising bank, because it's the seller's bank that advises the seller about the letter of credit. The buyer's bank is also called the issuing bank. The buyer goes to his bank and requests them to issue a letter of credit. Contract of sale is between the seller and the buyer of the goods. Contract of payment is between the issuing bank and the seller. The issuing bank assumes full responsibility in guaranteeing payment to the exporter of the goods rather than the importer. So how does a letter of credit work? The buyer placed an order with the seller. The seller wants to ensure he gets payment for his goods. He asks the buyer to pay him through an irrevocable documentary letter of credit. This is arranged by the buyer through his bank, and all costs incurred are for the account of the buyer. So, the buyer, also known as the applicant, requests his bank to open a letter of credit. His bank is known as the issuing bank, issues the letter of credit and sends it on to the seller's bank, known as the advising bank. The advising bank then advises the seller, known as the beneficiary of the letter of credit. When the goods have been shipped and the documents are presented to the seller's bank, once the documents are in compliance with the letter of credit, the seller will get paid. What's important when dealing with letters of credit is that the seller advises the buyer of any special arrangements or requirements before he goes to his bank to set up the letter of credit. The shipper should check very carefully the draft of the letter of credit when he receives it back from his bank to ensure that all the terms and conditions are correct and that he can comply with all the stipulations. The shipper should also check with his freight forwarder to ensure that shipping documentation required, i.e. the bill of lading, and dates to do with shipment and presentation of the documents can be complied with. There are three very important dates in a letter of credit. The first one is the date by which shipment should have occurred, so the shipped on board date. The second one is the presentation date, date by which the documents should have been presented to the bank. This is usually within 7, 14 or 21 days after shipment of the goods. And the last one is the expiry date of the letter of credit. Here's an example of how dates might work in a letter of credit. So the latest shipment date is the 14th of September. The goods actually shipped on board Friday the 7th of September. Documents should be presented to the bank within 14 days after shipment date. So this means the documents have to be presented to the bank by close of business Friday the 21st of September, and the letter of credit is due to expire on the 30th of September. So this is an example where the consignment has been shipped in compliance with the dates as stipulated in the letter of credit. Well, that brings this webinar to a close. Thank you for your time and attention. I hope you've enjoyed this webinar. If you have any queries at all, please contact either myself, Gráinne Thornbury, or Seamus Kavanagh at the Irish International Freight Association.